Hello, hello. I am sorry. Things keep going on and happening. Pardon being on vacation, y'all. Let's see. We're going to share screen. And we're going to look at Decastro versus Abrams. All right. So in Decastro versus Abrams, this is the Massachusetts case. Chile, for reasons that I don't know, has filed a second supplemental complaint. And I haven't looked through this yet, but remember he needs to prepare and file a amended complaint, not a supplemental complaint, an amended complaint to add a cause of action or causes of action in against YouTube. You know what? Let's check court listener Castro versus. There we go. Let's check. Whoop, hold on. Share this tab instead. I thought he was granted leave to file an amended complaint. So he was granted his motion to file an amended complaint. So YouTube doesn't have to file an answer until the third amended complaint comes out. Yeah, that's where we're at. So why we filed a second supplemental complaint, I don't know. So plaintiff files a second supplemental complaint to his first amended complaint and supplemental complaint in connection with his federal claim of copyright infringement. This supplement adds new claims for events that have occurred since the filing of the first amended complaint. Further, plaintiff supplements facts and copyrighted works and alleges as follows. Since the filing of the first amended complaint and supplemental complaint, all defendants, including unknown ones, oh my God, he makes my head hurt. Somebody did a wrong, and I still don't know who. He's just going to sue the whole world, I guess, in this one lawsuit. Have committed additional copyright and DMCA violations against plaintiff. Factual background: URLs of plaintiff's new copyrighted content are here. Here's the new copyrighted content, and then there's no actual claims of where these works were used in violation of his copyright. I should check to see if any issues so far. Any issues so far? Okay, no issues so far. All right, moving on. We have, share this tab instead. We have an answer in the California Superior Court case of Decastro versus Peter et al. This is Michael Puritini. This is his answer by defendant Puritini to plaintiff by notice of demurrers and demurrers to, and notice of motions and motions to strike portions of plaintiff's first amended complaint. I don't know why he titled it an answer. This, I don't believe, is going to be an answer. I have read this part. This appears to be a demurrer. And I didn't see anywhere in here where he answers. I see motions to strike. There is no answer. So I don't know what we're doing here. I love pro pers. Pro pers are awesome. Okay. This is an answer by notice of demurrers and motions to strike. To all parties and their attorneys of records, please, for the love of God, can we get some attorneys in here? Please, for the love of God. Please take notice that on August 1st at 8:30 a.m. or as soon thereafter as the matter may be heard, yada yada, he demurs and moves to strike. So a demurrer, for those of you who don't know, is governed by, share this tab instead, California Code of Civil Procedure, section 430.10. So the party against whom a complaint or cross complaint has been filed may object by demurrer for one of these following grounds. So these are the grounds that you can file a demurrer on. A, the court has no jurisdiction of the subject of the cause of action alleged in the proceeding. So this is subject matter jurisdiction. This isn't personal jurisdiction. This is subject matter jurisdiction. Say, for example, you were going to sue if Chile filed a copyright lawsuit against Puritini in California state court, the court would have no jurisdiction over the subject matter because copyright is 100% federal and the federal courts have sole jurisdiction over that. So this is subject matter jurisdiction. A is subject matter jurisdiction. B, the person who filed the pleading does not have the legal capacity to sue. If, for example, you are a minor and you don't have a guardian ad litem, then you would lack the legal capacity to sue until you had a guardian ad litem appointed for you. Normally, you file the lawsuit and you file the ex parte application for a guardian ad litem, at least in California. I've only done it once, and it was fairly perfunctory. C, there is another action pending between the same parties on the same cause of action. D, there is a defect or misjoinder of parties. A misjoinder of parties would be like if you join someone who didn't have a stake in it, or if you failed to join someone who had a stake in it. E, the pleading does not state facts sufficient to constitute a cause of action. So even if everything that the complaint pled is 100% true, you would still lose because there's no cause of action. That is what E means. F, the pleading is uncertain, ambiguous, and unintelligible. Think of a Rex Fredrickson pleading or a sovereign citizen pleading where you don't know what allegations they're actually making. I think this one is probably going to be a good grounds for demurrer, because if I remember, I haven't reviewed Chile's first amended complaint in quite some time since I made the video on it, but it seemed to be very ambiguous and unintelligible as to who he was suing and why. But it'd be something for the court to figure out. G, in an action founded upon a contract. Well, this isn't a contract, so this is not going to apply. And H, no certificate was filed as required by section 411.35. I don't know what 411.35 is, so let's give it a quick check. 411.35. What are we talking about? 411.35. In every action, including a cross-complaint for damages or indemnity arising out of professional negligence of a person holding a valid architect certificate, that doesn't apply. Engineer doesn't apply. Surveyor doesn't apply. An attorney shall file a certificate. All right, so that does not apply. So the grounds for demurrer, as I see them, at least as far as it comes to Puritini, where were we at? We're at 430. Here we go. Are that the pleading is uncertain and maybe even not state facts sufficient to constitute a cause of action against Puritini, perhaps. I believe that the subject matter jurisdiction, California does have subject matter jurisdiction. And there you go. Now, I don't know. See, I don't know where you. I always thought. Now that I'm reading this, I always thought you could file a demurrer if the court lacks personal jurisdiction. But I guess but that would be a different kind of motion. I always thought demurrer was for personal jurisdiction too, but I guess not. All right, and then motions to strike. Motions to strike are basically where you want to get rid of. Demurrers. One thing to be noticed to take note of on a demurrer is that you have to demur against each cause of action. All the causes of action that you are demurring to, you have to say, I'm demurring to this action or to this cause of action, I'm demurring to this cause of action. And the ones that you don't specifically state you're demurring to are, you have to answer, unless they don't apply to you, in which case you're golden. A motion to strike is different. You're actually looking to eliminate specific language. Now there is a requirement that you do meet and confer. I don't know if he's met and confer. I believe there's a requirement in here that you actually have to state that you did meet and confer. And you're looking to strike out irrelevant, false, or improper matter inserted into any pleading. Now, what they mean here is not that you can't prove something is false in the long run. What you're looking for here is actually things that are like the court can take judicial notice of, that something is false. Like, say, for example, you said, I live in Sacramento next to the Mississippi River. Well, obviously, you can't live in Sacramento next to the Mississippi River. Okay, let me rephrase this because I don't know if there's a Sacramento somewhere along the Mississippi River. So let me be a little bit more specific. You can't say, I live in Sacramento, California, right next to the Mississippi River. That a court could be like, yeah, that's false. You can't say, the court can strike. So there's a difference between statements that are incompatible and what's the word? Antagonistic, I think it is. Incompatible statements are like he breached the contract, and in the alternative, if he didn't breach the contract, then I don't know, he defaulted or whatever. Something like that where you're pleading in the alternative isn't necessarily going to be something to strike. What they're talking about, what it needs to be is it needs to be antagonistic. Like paragraph 1 where you say, I'm 42 years old or whatever age. And then in paragraph 2, you say I'm 45 years old. Paragraph 3, you say I'm 44 years old. Well, those are going to be antagonistic to each other. You can't be all three of those ages. It's not like you can make an argument that you're all three of those ages. It's not like there's some technical issue where you can be all three of those ages at the same time. So that would be antagonistic. And so that's kind of what you're looking to strike out. So the demurrers are made on the grounds that plaintiff's assertion of jurisdiction in paragraph 7 of his complaint is inconsistent with facts. Now, these are going to have to be the facts in the actual complaint. So the facts in the complaint have to be inconsistent with, and actually not necessarily inconsistent with it, they have to be antagonistic to it. Now, the court could find that these facts, I'm not pulling up his old, the first amended complaint. So the court could find that these are actually antagonistic, that they're inconsistent enough that there's a problem. But just because it's inconsistent doesn't mean that it's necessarily going to be struck. And this court may therefore not have jurisdiction over defendant Puritini. So here's I think what he's arguing here is personal jurisdiction. All causes of action failed. Personal jurisdiction is different than subject matter jurisdiction. Subject matter jurisdiction was like, can this court hear a contract dispute? Can this court hear a family law dispute? Can this court hear a criminal dispute? As opposed to personal jurisdiction is, can the court make orders affecting you? Are you subject to this court's jurisdiction, you personally. And typically the way a court gets jurisdiction, personal jurisdiction over a defendant, is to have that defendant served properly with a summons and a complaint. That's typically how a court gets jurisdiction over a defendant. All causes of action failed to state a claim against defendant Puritini upon which relief can be granted. Okay, that's a reasonable statement to make. The first, second, third, fourth, fifth, sixth, and eighth causes of action are known by defendant Puritini to contain misstatements of facts that have been presented to support the claims made. That's weak. I mean, I'm not going to fault him for saying it, but the court's going to have to assume, for the purpose of a demurrer, that that the allegations made in the pleading are true, unless it's something where the court can take judicial notice of it. And by judicial notice, I don't mean that the court's going to go out and watch all these videos. If the video is not referenced in the complaint, then it's not something that the court can watch and make a determination of fact and come back with. For the purpose of demurrer, you have to assume that the facts pled in the complaint are true. The court has to do that. And all causes of action are written as plaintiff against all defendants, but fail to make it clear how all defendants are incorporated into the cause of action. So that would be the demurrer grounds for incomprehensible, unintelligible. The motions to strike are made on the grounds that portions of plaintiff's complaint contain irrelevant, false, or improper matter, and therefore should be stricken due to CCP 435 and 436. These demurrers and motions to strike will be and hereby are based on this notice. The attached demurrers and motions to strike, the memorandum of points and authorities in support filed concurrently herewith, the appendix of authorities filed concurrently herewith. Did I get an appendix of authorities? Maybe it's attached to something. Maybe it's attached. Shazbot. Thanks for telling me, guys, that I was on the wrong thing. There's a table. There is a table of authorities and a table of contents. Okay. I guess I did get it. All right. Sorry. I'm new at this. All right. So the demurrers and motions to strike. Puritini demurrers to and moves to strike. All right. So the first demurrer is jurisdiction. So I'm assuming this is and venue. So okay. Puritini is not a resident of California, and no action alleged to have been committed by defendant Puritini occurred while plaintiff was in California. Cal Code of Civil Procedure 1310A. 1310A. All right. We'll go back to share this tab instead. 1310A. 1310A. The court has no jurisdiction of the subject of the cause of action alleged in the pleading. We're going to do a little Google search. Demurrer personal jurisdiction, California. Well, let's put quotes on it. I thought you could demur to personal jurisdiction, but I didn't see it in the list. Oop. All right, 14.10. 418.10. Objection to jurisdiction. So you can serve and file notice or motion to quash service of summons for a lack of, this is for personal jurisdiction, is jurisdiction of the court over him or her. So that is not, oopsie doodles, right? It's so now in Puritini's favor, before we get all upset and think that, this is going to go downhill for him, the court is going to listen to what he has to say. He's saying that this court doesn't have personal jurisdiction over me, and then the court is going to be like, okay, well, that's not a demur, but if we don't have personal jurisdiction over you under 418.10, we don't have personal jurisdiction, yada yada. So the court can most likely massage this and actually not grant the demur, but make a finding that he doesn't have, they don't have personal jurisdiction over him, and quash the service of summons, if that's what they find. All right, so we're going to go back to this tab instead. All right, so defendant Puritini is not and no action alleged to have been committed by Puritini occurred while plaintiff was in California. So if I think California still has jurisdiction over causes of action, has subject matter jurisdiction, not necessarily personal, but subject matter jurisdiction over causes of action that affect their residents. And so I don't think that's a proper subject matter demur. Defendant Puritini objects to plaintiff's claims that the court has any jurisdiction over him in this matter. Again, this is personal jurisdiction. Plaintiff has failed to establish the minimum contact defendant Puritini must have with the state of California. Okay. I think the if I remember, the First Amendment complaint was pretty vague as to how anything applied to Puritini. So, but again, this is a personal jurisdiction issue. All right, demur to the first cause of action: libel, slander, and false light. The first cause of action in the First Amendment complaint fails to state facts sufficient to constitute a cause of action against Puritini. I agree, or at least from what I remember, I agree. When the public figure doctrine is appropriately applied, the first cause of action fails to state facts sufficient to constitute a cause of action against any defendant. That doesn't make any sense. So the New York Times versus Sullivan standard, the malicious, what do they call it? Why am I blanking out? Sorry, I haven't had a lot of sleep lately. Actual malice. New York Times versus Sullivan, actual malice standard for a public figure, limited public figure, something about like something to do with public news, things like that, like things that are in the public eye. What the actual malice standard requires is that you show not just that the statement was false, but that the speaker acted with actual knowledge that the statement was false, or acted in reckless disregard to the truth or falsity of it. Like if the person who like let's say theoretically, just for shits and grins, let's say that someone said that Trump was actually a transgender woman, right? The actual malice standard would require that Donald Trump, if he sued that person, would have to show that the person who said that about him knew that statement was false, or should have known. And Trump has been in the news forever. It's highly unlikely that anybody doesn't know that Trump wasn't born male and still identifies as male. So that's kind of what we're looking for. So it doesn't the public figure doctrine, the New York Times versus Sullivan actual malice standard, doesn't mean that Puritini wins necessarily. It doesn't mean that as a matter of law Puritini wins. It means that Decastro is going to have to overcome that hurdle If the court finds that Decastro is a public figure, then Decastro will have to overcome that hurdle of the actual malice standard. It's not a guaranteed win. So that's a rather poor argument by Puritini. Battery. The second cause of action in the First Amendment complaint fails to state facts sufficient to constitute a cause of action against Puritini. Again, most likely, evidence exists that suggests. Did Peter write this? Jesus Christ. Evidence shows the actions described by. Evidence exists that suggests the actions described by in the second cause of action, when presented accurately, are insufficient to constitute a cause of action against any defendant. I guess he just really wanted to write extra stuff. I have no idea why he said that. It doesn't make any sense. Trespass. The third cause of action in the First Amendment complaint fails to state facts sufficient to constitute a cause of action against defendant Puritini. Am I showing this one? Perfect. Harassment and civil conspiracy. The fourth cause of action fails to state facts. Perfect. Fifth one, stalking, cyber stalking, and civil conspiracy. Fails to say, okay, perfect. And then now he adds, it also fails to establish the elements required to constitute a cause of action against any defendant for stalking. It fails to state facts sufficient. It also fails to state facts sufficient. Like, give it up, dude. Like, you don't have to repeat yourself. Assault, the sixth cause of action in the First Amendment complaint, yada, yada. Evidence exists that suggests the action described in the sixth cause of action. Bleh, that's stupid. Economic interference. Oh, apparently Chile must have misspelled something. The seventh cause of action in the First Amendment complaint fails to state cause of action. Perfect. Eighth one, perfect. Demur by Puritini to prayer for relief. Can you demur to a prayer for relief? That's a good question. Can you demur to a prayer for relief? The prayer for relief isn't a cause of action. Did he include allegations in his prayer? I don't remember. If he included allegations into his prayer, I would be comfortable demurring to it if there were allegations in there. If it was just, based on the foregoing, defendant or plaintiff prays the court grant him compensatory damages in the amount of X, punitive damage in the amount of X, costs in the amount of X, and other relief as appropriate. If you just said that, then I don't think you would. Yeah. So see, he says it does. So maybe he's just covering his bets. Maybe there were allegations in there. I'm not going to hold that one against him. Motion to strike portions of the introduction. Defendant Puritini moves to strike plaintiff's statement contained in paragraph 1, page 1 and 2. He didn't do a meet and confer on this. You should have done a meet and confer, but whatever. I don't know why you really care about striking stuff in the introduction, but I guess, I mean, you can't be too safe, right? Page 1 and 2, lines 23 to 3. Paragraph 1, from page 1, line 23 to page 2, line 3 of the First Amended Complaints introduction. The words beginning, although plaintiff has been arrested many times, and ending historically over 20 years old. The two sentences contained within these lines are incompatible. Plaintiff cannot claim to have a criminal record and claim he has not been convicted of a crime. He can't claim to have a criminal record and claim he has not been convicted of a crime. Plaintiff's statement of protesting or otherwise covers every possible action that could lead to a conviction. The statement is false and should be stricken pursuant to California Code of Civil Procedure 435 and 436. Well, so I guess a lot of it would depend on how you define criminal record. I think Chile defines criminal record as having a conviction. And I don't, well, I think he does have a conviction. Yeah, he has conviction. Or did he plead guilty to the, I know that pleading guilty is the same thing as being found guilty, generally speaking, like as far as your criminal record is concerned. But I think Chile draws some really fine lines, and I don't think they're necessarily entirely accurate. But I don't know why you'd want to strike that. I guess if you got nothing to do but file motions, sure. It doesn't really change anything necessarily, but all right. Motion to strike portions of jurisdiction and venue. Defendant Puritini moves to strike plaintiff's statement contained in paragraph 12, lines 2 to 3, or page 2, line 25 through page 3, line 1 of the First Amendment complaint's jurisdiction and venue. The words beginning general jurisdiction is proper and ending and the harm occurred within that county. Pursuant to Code of Civil Procedure 435 and 436, many of the claims made by plaintiff occurred while he, the defendants, or both were outside of the county of Los Angeles. The statement is false and should be stricken. Well, so the court is again going to have to take the allegations made in the complaint as true, unless there is something in the complaint that contradicts them directly, antagonistically, or the court can take judicial notice. So that's, I don't project him winning on this ground. Yeah, I could be wrong, but I don't believe Puritini saying this is false is going to move the court to require Decastro to strike that particular those particular lines. Motion to strike portions of parties. Defendant Puritini moves to strike plaintiff's statement contained in paragraph 12, page 4, lines 14 to 16 of the First Amendment complaint's parties. The words beginning Puritini is an agent of Peter and ending pretending to be a private investigator and military police officer. Puritini is not an agent of, it's the nuh-uh defense, and plaintiff fails to establish otherwise. He doesn't have to establish otherwise. In his complaint, he makes the allegation. And then during the discovery process, he either gets either he has the evidence he needs to prove it, or he intends to get it through the discovery process. And then at the end, at trial, is where he has to establish it. So sorry, Blue Bacon. Defendant Puritini does not harass people, the defense, perfect, nor does plaintiff provide evidence to the contrary. Evidence is provided at trial. He has to make allegations in his complaint. Defendant Puritini is, in fact, a private investigator and military police. As these statements are false, they should be stricken. Well, he gets to prove, see, what he's asking the court to do is accept his word, Blue Bacon's word, over Decastro's word, but that's not the way it works. Not at this stage. At this stage, the court assumes all the allegations made in the complaint are true. And Puritini is going to have to go through the process like anybody else. Motions to strike portions of the first cause of action. Defendant Puritini moves to strike plaintiff's statement contained in page 5, line 20 of the First Amendment complaint's first cause of action. The statement consisting of plaintiff against all defendants pursuant. Okay. The statement is not drawn or filed in conformity with the laws of the state, as plaintiff fails to establish each individual's contributions to the cause of action. I mean, I guess you could ask the court to strike that. I think the court's going to deal with this part in the demurrer. The court's going to say that Decastro has sufficiently alleged a cause of action against Puritini on the first cause of action or not. I don't think the court's going to strike that particular line of plaintiff against all defendants. Puritini moves to strike paragraph, I'm sharing this tab, yes. Page 20, or paragraph 20 on page 6 of the First Amended complaint's first cause of action. Puritini did not title the video containing the alleged defamatory statements, nor did he make any of the defamatory statements alleged by plaintiff. The defamatory nature of the statement is, according to plaintiff, based on a Ben-verified report, but defendant Peter, who published the offending video, had received information about the accusations from alleged witnesses and direct communications with LAPD. So there's a couple problems with this. First of all, trying to introduce facts in your motion to strike, not a winning proposition, number one. Number two, this is hearsay. You are saying that Peter says she got this information from alleged witnesses. That'd actually be double hearsay because these, well, I guess if the witnesses were actually firsthand witnesses, maybe, and direct communications with LAPD. Well, again, you don't know that. You're assuming that Peter is telling the truth. Now, I personally believe that she's telling the truth in this particular matter, but the court doesn't know that, and this is not proper. Plaintiff has previously stated on record he took a deferment plea after being charged with possession and sale of narcotics, as well as manufacturing a controlled substance. Okay. Again, these are facts that you're now, again, you're saying, but he said this somewhere else. Well, great. But is that in his complaint? You have to look at the complaint. You're making a fact argument here. The purported facts supporting the alleged defamatory nature of the statements Puritini did not make should be stricken for being false. The rest of the paragraph is irrelevant. Without those purported facts, it should be stricken. Well, again, I think the court is going to deal with this with the demurrer and not with a motion to strike. Defendant Puritini moves to strike the remainder of the first cause of action contingent upon striking of plaintiff against all defendants pursuant to California Code Civil Procedure 435, 436. If defendants are not named, the cause of action is not drawn or filed in conformity with the laws of the state and should be stricken. Well, like, that's kind of not necessarily. You should be able to figure out, not from the caption of the thing, but from the actual allegations contained in the paragraphs, who this is against. The caption is mostly for the convenience of the reader. It's not necessarily controlling. And I would love for someone to find me some statute or case law that says otherwise. They're in the Judicial Council of California has form complaints, judicial council forms that don't have the against part in there necessarily. I guess on some of them you can add that in, or you know what? Let me double check real quick before I get all too far ahead of myself. California typing Judicial Council form complaint to breach of contract. Sure. Breach of contract. All right. Shut this tab instead. This is the cause of action attachment to the breach of contract form, and it doesn't say against on there. Now, best practice definitely would be to include on there who you're addressing the particular cause of action against. So best practice definitely, but I don't believe that's mandatory language. As long as it's apparent in the pleading who the cause of action is against, I don't think there's a big deal. All right, motion to strike portions of the second cause of action. Or is he going to do this for every cause of action? Christ. Why? All right, so he wants to strike statement of, again, plaintiff against all defendants. That's pretty stupid. Warrant is not a defendant in this case. The paragraph about his actions is therefore irrelevant and should be stricken. J.L. Warrant. is not a defendant in this case. Okay, sure. If the court grants the motion to strike, they're going to give Chile leave to amend. I'm going to guess, and then all Chile has to do is add JL warrant as a doe. Except that would open him up to removal to federal courts. Why isn't this removable anyway? Oh, it already is removable. Never mind, because Kate's in there. Sorry, I'm dumb. And then he wants to strike it all. Okay, third cause of action against all defendants again. Masshole members is not a defendant in this case, and unverified claims by this entity do not establish involvement of any defendant. I think that's where unidentified masshole members were making allegations or making statements about Chile and Chile's whereabouts, if I remember correctly. I don't necessarily think that's irrelevant. I'm gonna guess this is gonna be handled by demurrer. Anyway, I think most of these are gonna be handled by demurrer and not by a motion to strike. But I don't know if it's irrelevant entirely. Chile's trying to show that there's this group that's acting, and he has does that are named, or unnamed does. So I'm gonna guess that a court would not strike that. All right. So plaintiff describes a legal action alleged to have been committed by defendant Peter. A legal action alleged to have been committed by Peter. I don't know what that means. The paragraph is not relevant to establish any defendant has met any elements of trespass. I mean, so sometimes there's background in complaints, and just because something isn't directly relevant doesn't mean necessarily it's irrelevant. It could provide motivation. It could provide the context by which one or more parties are going to address or interact with the situation to establish frame of mind and things like that. So there's a lot of irrelevant stuff in any complaint, and moving to strike everything is, I don't know if the court's going to waste its time doing it. All right. Third cause of action does not establish any defendant was responsible for the actions described. Nor does the paragraph relate to trespass against plaintiff. I don't think he has any real property. I don't think Chile has any real. If I remember correctly, he was alleging a really shitty trespass allegations. That trespasses on real property, and like, if you toss a rock onto someone else's lawn, that is a trespass as far as suing is concerned, because it caused damage to their property. So I don't know that he has any property damage. So again, I think third cause of action is going to be handled by demurrer. Fourth cause of action against all defendants again. Plaintiff describes an act by defendant Peter and claims it was defamatory and painted him in a negative light. Paragraph belongs in the first cause of action, but has been improperly asserted into the fourth. Well, if it belongs in the first cause of action, then it wouldn't be struck. It would just be another allegation that supports the first cause of action. Puritini moves to strike the statement made by plaintiff contained in paragraph 10, line 38, line 17, 18, contained in paragraph 10 of the First Amendment complaint's fourth cause of action. Statement consisting of who is not a public figure or a limited public figure. So that was a legal conclusion, and that's something the court is going to determine. arguing that he is a limited purpose public figure and is stated he's a public figure, blah, blah, blah. That is a legal conclusion. It is not a fact. I know it sounds like a fact, but it's a legal conclusion. And I don't think a court's going to strike it because it is a legal conclusion. Now, can a court strike a legal conclusion? Sure. But why? Why bother? Like, it doesn't change anything. Puritini is going to have to prove, in order to get the actual malice standard applied, he's going to have to prove that Decastro is a public figure or limited public figure or whatever. And then if he does that, then Chile's going to have to rebut the actual malice standard and show that Puritini acted with knowledge that his statements were false or with reckless disregard as to whether his statements were true or false. So it's not something you hammer out here. All right. And then the defendants work together in an agreement to commit these wrongful acts. Well, it's an allegation, and I don't think that's going to get stricken. Just because Puritini says it's false, I mean, the court has to assume allegations made in the complaint are true, with a few minor exceptions. And then remaining blah, blah, blah. Fifth cause of actions, yada, yada. Beginning with Puritini has been and with at least November 2022. Puritini has never sent plaintiff emails for like they're from a court. Well, again, that's a fact argument, improper. All right, defendants work together in an agreement to commit these wrongful illegal acts. Again, this is a fact argument, so it's improper. All right, fifth cause of action. California Civil Code section 1708.7 requires a tort of stalking to prove a defendant violated a restraining order or issued a credible threat to plaintiff's safety or the safety of plaintiff's family, engaged in a pattern of conduct that caused plaintiff to reasonably fear for his or for his family's safety, and the plaintiff on at least one occasion clearly and definitively demanded the defendant cease and abate the conduct. Plaintiff has not established all elements has been met by any defendant. His claims are therefore not relevant to the tort of stalking and should be stricken. Okay. The fifth cause of action, stalking, again, that is not controlling. That is a header. It is helpful for people to figure out what your theory on it is, but the court is going to look at the actual language. And if the thing that plaintiff has said is stalking isn't the tort of stalking, but it is perhaps negligent or intentional infliction of emotional distress or otherwise behavior that plaintiff can recover from, then it is still a cause of action. It might not necessarily be the specific tort of stalking, but if it's recoverable, then it gets to stay in. Headers, don't get too wrapped up in headers. Strike the entire. All right, 6-1 against all defendants, yada yada. Statement consisting of this stalker pursuant to California, defendant did not meet the requirement elements. Again, I think that's a waste of time. While down the block and ending with begin an offensive defensive. Plaintiff's own video. So again, this is going to be a fact argument, and it's improper. It's not, you're not supposed to be making fact arguments and trying to bring in new facts. Oh, his own video shows it. Well, that means the court would have to watch a video and make a finding of fact that is in fact a video, yada, yada, yada. So no. All right. Stalk me. Defendant Clement did not. What about the penal code? I mean, would the penal code have worked for stalking? And again, plaintiff's use of language. Oh, he wasn't stalking me. He was just following me around, harassing me, yada, yada, yada. I mean, 6 of one, half a dozen of the other. All right. Blah, blah, blah. Blah, 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 blah. Blah, blah, blah. Blah, blah, blah. Motion to strike portions of prayer for relief. All right. Failed to establish a defamatory statement was made by all defendants, and injunction against defendants would therefore not be possible. I don't know if the court's going to do that. It's the prayer for relief. It is not an allegation. It's a prayer. It's not an allegation. It's prayer. It's not an allegation. It's a prayer. It's not an allegation. It's a prayer. And these are all prayer for relief. Okay, so there you go. Why do you attach this? Why did he attach? Why would you attach? Did it automatically attach that? That's really weird. Because wait a minute, he would have to file it. He'd have to file, or you just paid for it. Oh, okay, he paid for it, and then I guess maybe it's court policy to payment date was 12/31 of 1969. Well, there's your problem. You got a little ahead of yourself. There's a glitch in the matrix. All right. So then, what else do we have? We have a memorandum of points and authorities. All right. Blah blah blah. So 11 pages. I think we can make it. Table of authorities: Buckley versus Vallejo. Supreme Court case. Oh boy, lots of Supreme Court cases. Lots of Supreme Court cases. Oh, we got Capellas v. Kaufman. Nice. We got a California Supreme Court case. Another U.S. Supreme Court case. Another U.S. Supreme Court case. Another U.S. Supreme Court case. California Court of Appeals case. And another California Court of Appeals case. Oh boy, this is going to be fun. And you should have renumbered these because 12 comes before 13. So just saying. All right. Support for motions. Plaintiff fails to establish jurisdiction. What kind of jurisdiction are we talking about? What type of jurisdiction are we talking about? Because there's personal and there's subject matter. So concerns regarding plaintiff's residency. Plaintiff's residency. Concerns. We're going to concern troll this. The address plaintiff lists as his address in this case matches the address used in a submission in case number, yada, yada. However, plaintiff's former landlord stated, so we got a little bit of hearsay. Nice. Support for motions. Nice. A little bit of outside facts based on hearsay. Love it. Not even a signed affidavit under penalty of perjury. Just straight up hearsay in the support for the motion. Brilliant work. So a request for civil harassment restraining order was filed against plaintiff. The person seeking protection stated plaintiff was squatting at this address. Again, this is again going to be hearsay. Plaintiff published a video. Again, this is. So, all right. So two things. Number one, if true, then plaintiff is still a California resident. So he's still a California resident. I don't even. But why are we bringing in facts? Why are we making a fact argument? Lack of minimum contacts. Now, minimum contacts. Let me go back to my international shoe days. Minimum contacts is a test to see if a corporation can be sued in a state. And I think That was very loud. That was very loud. Jet was awful low. Okay, so where are we at? Minimum contacts. And didn't they update minimum contacts? Did they update the test? Now you can now you have to sue. Now the proper state to sue in is where the headquarters is. I think they updated it. I think they updated that. But minimum contacts, I remember that international shoe is minimum contacts still used. I thought they changed it. Mm-hmm. All right. Well, close that up. All right. Where are we at? Plaintiff makes allegations against defendants, blah, 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 incorporating the assertion defense were located in Los Angeles County at the time the alleged actions occurred. Defendants would have outside of California during the allegations addressed in those paragraphs. However, defendants would have been outside of California during the allegations addressed in those paragraphs. So this is probably why you do a different motion instead of a demurrer for personal jurisdiction, because you're going to have to bring facts in. You have to bring facts in. The alleged actions committed against plaintiff in paragraphs yada yada occurred while plaintiff was by his own admission outside of California. Doesn't necessarily have anything to do with it. As long as there's like one action that you could sue under in California, where California would have personal jurisdiction over you, then sure. The events and allegations described yada yada occurred when neither plaintiff nor named defendant was within the state of California. In the absence of those minimal contacts, exercising jurisdiction would be inconsistent with the Constitution. Well, I hate to break this to you, Sunshine, but a cause of action for defamation can be brought in the home state of the plaintiff. It's been done, so sorry. And I don't think just citing international shoe is going to get you very far. B, plaintiff fails to state facts sufficient to constitute a cause of action, makes false, irrelevant, and improper statements. Okay. First cause of action. Only 2 defendants are named as alleged participants in these activities. Furthermore, defendant Puritini never made the claim plaintiff has based his cause of action around, nor did he have any input on the title of the publication, which was a live stream and not an article, as plaintiff has erroneously claimed. I think we're going with he says this is false, but I think this would go more. I think a lot of Puritini's demurrers are going to be properly grounded, properly based on being ambiguous, vague, ambiguous, uh, unintelligible. Plaintiff believes he's a public figure. Okay, why does it matter? So now we're more outside evidence in this. Okay, establishes he believes he's a public figure. Um, well, so maybe not. I mean, let's just assume that the court just decides to throw all the rules to the wind and actually entertains this line of thought and accepts these allegations as true. Number one, would Chile be a public figure? Well, it wouldn't matter whether Chile said he was a public figure or not, because you have to, like, if you go down into the streets of Sacramento and you find some crazy guy who thinks he's Michael Jackson, does that make him Michael Jackson? If he says that he's famous, does that make him famous? If he says he's a public figure, does it make him a public figure? Just because someone says that they are this thing does not mean that you can you could come to the legal conclusion that they are in fact that legally defined thing. Blah blah, and therefore subject to the action mile standard. There you go. Knowledge of the statement was false or with reckless disregard is whether it was false or not. New York Times versus Sullivan. Excellent use of citations. Completely useless, but excellent, but useless. Plaintiff is a limited purpose public figure. Again, who cares? I just don't care. I don't care. We've already gone through this. He's pleading a bunch of facts, and again, the facts are useless. Plaintiff intends to run for public office, unless he said it in his actual complaint, then it's useless, and it doesn't matter. Second cause of action: plaintiff fails to name Puritini. Good. He's aware of a video. Well, again, that video, unless it's actually addressed in the complaint, court can't consider it. Court won't consider it. Third cause of action: plaintiff states members of defendant Peter's Discord claimed to have stolen his van, despite referring to a police report naming a thief who is not one of the defendants. Did he actually say the name of the thief in the complaint? It'd be interesting if he did. Plaintiff states a bag of dog feces was left on his porch and chocolate was placed on his door handle, but in a video, blah blah blah. Outside facts. Sent an email to Puritini, which stated, "You sent people to my family's home." Really? Did he misspell families that bad? Family apostrophe S, not families. Kate sent people to my house in Denver. Her trolls attacked my fight camp, got my Airbnb canceled. Plaintiff is referring to process servers defendant Puritini hired to serve an approved protection order to plaintiff while he was believed to be residing with family members. Plaintiff placed the blame on defendant Peter for the events in Denver, not defendant Puritini. It's unclear why that blame has shifted. Again, these are outside facts. That's interesting to learn. I did not know that. Fourth cause of action. Plaintiff published his own phone number in his blah, 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 which may account for the end. Again, these are facts that are outside of the pleading. It says he's not a public figure, limited public figure. Great. Doesn't really matter. Fifth cause of action. Plaintiff, paragraph 47 does not contain evidence of plaintiff's theory of an AirTag planted on or in his vehicle, and plaintiff fails to name Puritini as someone involved in the alleged placement of an AirTag. He doesn't have to provide evidence. He has to make the allegation. He has to allege facts sufficient that, if true, would support a cause of action. Plaintiff owns a phone that can search for AirTags in, on, or around his property. Again, this is a fact that isn't what blah. In fact, blah. Also, blah. He fails to establish defendant Puritini made any malicious communications to him about a tracking device. Okay, that's failure to allege facts sufficient. Perfect. Countering plaintiff's claims. Countering them now. We're not demurring to them. We're countering them. Plaintiff regularly reveals blah, blah, blah. Merely identifying is not actionable. Failed to establish participation in the mass communications of information, blah, blah, blah. Fails to establish, here we go. He fails to establish Puritini created any YouTube accounts to harass plaintiff. Period. That should be a period. He lists several states that aren't California, despite previously claiming all unlawful practices were committed within the county of Los Angeles. As long as one of them is. He also repeats a vandalism and theft claim from the third cause of action. Okay. Discrepancies have already been noted with the vandalism claim. Plaintiff's stolen vehicle was not recovered from under a body of water. Defendant Puritini was not named as participant. Okay. He denies claim he's a dangerous man who carries guns and is wanted by the police in multiple states. Congratulations. At this time, Puritini is only aware of 2 active warrants. Again, these are outside. Well, I guess, all right, active warrants. Can the court take judicial notice of the active warrants? I think the court can. So at this particular juncture, if Puritini was smart, he would have asked the court to take judicial notice of 2 active warrants out of the state of Ohio that have been issued for the arrest of plaintiff. However, among the, well, at this point, no, he doesn't have a warrant out of Nevada. I think he hasn't failed to appear on that one yet. However, among the messages sent to defendant Puritini after plaintiff published defendant Puritini's home address were these: I want to meet you where no one can stop it, not a public blah, 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 blah. Well, no, it doesn't, because these are facts. You got to plead facts. You can't say this establishes, because these are facts that are outside of the scope of the complaint. More facts. Fails to establish defendant Puritini participated in or encouraged leaving negative reviews. Fails to allege would be a better way of putting it, but that's what we're looking for. We're not looking for him to establish it. We're looking for him to fail to allege facts sufficient to show Puritini participated in or encouraged leaving negative reviews on a business. More outside facts. 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 6 cause of action assault. Blah, blah, defendant Clement. Clement plotted. Yep. It's possible that he read 18 U.S.C. 922 G2 and 3, which establishes a fugitive from justice or unlawful user of any controlled substance may not carry a firearm in interstate commerce. And I guess Clement knew at that point in time that he was packing or something. I don't know. That's stupid. Like, trying to justify this shit. That's stupid. He did this. He did that. Plaintiff fled. He did that. Yeah. More facts. Any defendant may have reasonably believed it would be appropriate to conduct a citizen's arrest in accordance with California Penal Code 837. So the operating idea that Blue Bacon has, first of all, don't do this. Please, nobody, for the love of God, nobody be so stupid as to try to make a citizen's arrest on anyone unless you see them actually committing a crime, unless you see them currently actively committing a crime. And even then, I don't necessarily recommend it. Call the police, let the police handle it. That's what they get paid to do. They get paid to run into those dangerous situations. Oh my God. Oh my God. So his operating assumption is that Clement was attempting to make a citizen's arrest in accordance with the California Penal Code, Section 837. Now, I watched some of that video, and Clement was not attempting to do that. That is the stupidest fucking thing I've ever heard. Well, I've heard a lot of stupid things, so it's probably not the stupidest, but that's a stupid fucking thing. That is a stupid fucking thing. A lawful citizen's arrest would not be assault. Well, you're assuming it's lawful. You're jumping to a legal conclusion. Blah blah blah. And then again, outside facts. In a video about journal. Oh, so more outside facts. Puritini's publications do not consist primarily of content outside facts. No contract existed. Facts, outside facts. Requirement to pay the fees, outside facts. Plaintiff stated outside facts. All these are outside facts. Prayers relief. I'm not going to worry about those because that's really fucking stupid. Conclusion. Plaintiff fails to establish this court's jurisdiction over defendant Puritini, fails to state facts sufficient to constitute a cause of action against defendant Puritini, wrote every cause of action in a manner that was not drawn or filed in conformity with the laws of the state. I mean, he never once stated how they were not in conformity or like which law, what did they do wrong? Is there some sort of California rule of court? And made many false statements in furtherance of his claim. Yeah, well, again, going back to, I think a lot of this is going to come into play. Mostly, if the court does sustain demurrers, I think a lot of it is this. And by uncertain, I mean uncertain as to how any of the causes of action relate to Puritini. That is my best guess. So I think Puritini has good chances of success, but based on this and not based on the bullshit that he tried to throw in there. Okay, God, that was long and exhausting. I hate pro pers. Pro pers suck, especially cocky pro pers like Puritini who think their shit doesn't stink and that because they were military police that they are somehow knowledgeable about the laws. This could be fun, yes, in quotes. I agree. You're hoping I stand up sometime during this live? Well, that would definitely lose the PG rating that we've tried so hard to curate. Hey, yeah, come on, show us that 5-inch rooster. Are you talking about Inigo or Fabio? Both of them are fairly big boys. Pre-trial, okay, you're looking like a homeless trucker. Good, my plan is working. Hello from San Antonio. Where are the dogs? They are both sleeping right down there. You might even be able to hear them snoring. It's nice and warm out. Hello, pants check. Nope. A good day. Audio's good. Glad to hear it. It's Merb and he's live. Yes. Word, I'm here in the live. Yes, you are. He must have remembered he had a court case in Massachusetts. Maybe. Good afternoon. I've been waiting for this live stream for the past hour. Boy, is my life boring. Well, sorry. Damn, it's a good moda fucking day, brother. It is a beautiful day. Tomatoes. Hope everyone is doing well. On one of his recent videos, he said he needed to add the URLs of his recent videos to his lawsuit so it'd be more copyright infringement. At least according to him, that's likely why he did this. Yeah, but it's stupid. He is literally, clearly supposed to be filing a second amended complaint. Hi, hope you're all doing awesome. Vlad, what's good? At least you have life at Tomatoes more than I could say sometimes. Because Little Chili is a moron. Yes, he is. Blanco, Paul, can you just keep supplementing over and over? Supplements, I don't know if you answered this, but a supplement to your complaint is to allege any new causes of action that have occurred, that have come into being, that have become ripe, that you could sue over since you filed your last supplement or your complaint, whichever is most recent. So if, for example, Kate, I don't know, does another copyright infringement on him, he could allege the subsequent copyright. So yes, you can keep adding supplemental complaints if they keep. I mean, I guess at some point the court might get tired of it and cut things off, but I believe you can keep adding them indefinitely if they keep accruing causes of action. I remember him claiming that also. Smiley faces is Blanco from the Bronx. From the Bean, brother. No, the list in front of you. No, the list in front of you are the violating works. Okay, that's the other Benny. But he hasn't copywritten anything. I know that's a bit of a monkey wrench, a spanner in the works, as they like to say. Yep. I'm Benny Blanco from Bean. Hey, Merb, who was your favorite Petticoat Junction girl? There's a little hotel and it's head of trucks at the junction. Petticoat Junction. I don't know. I don't remember. How much more does it generally take for the judge to sanction him? Does he get more leniency being pro se? For a court to sua sponte, like on its own, sanction him, probably a lot more. For the court to grant sanctions as part of a motion, it depends on what the motion is. Well, FFS, if Chile files enough amended complaints, something has got to stick, right? Well, these are supplemental, not amended. Any truth to the rumor I started that Blandino is ghostwriting Chile's motions? I don't know that he is. I don't think so. I was a Bobby Joe man. All right. Good morning. Zoom in. We can't read it. Oh, too late now. Merb and the No Pants Band has a new hit single, 5-Inch Rooster. Okay. When will Chile see the governor of Alaska for sitting in his seat? Yes. Gas control rich, okay? Stout, and stout pro per strike again. Awesome. 5 minutes alone. He has admitted that he just wants to waste their time and money, so all this is BS anyways, probably. I still say that Merb does these live streams pantsless. Yes, I am pantsless. Know what's great about being a woman, not wearing pants and getting away with it? Well, it's kind of cheating if you're wearing a skirt. I could just pretend I'm Scottish and wear a kilt, but no fun. Too pantsless, I know. Well, if you don't put on pants, they're all pantsless. I want to know when the lawyers involved are going to show the judge that this lawsuit is just intended to bleed people dry. Well, they have. That's been included in several motions and responses by, what's that guy's name? Wish, of the Make-A-Wish Foundation. And it doesn't seem to have convinced the judge much. The judge is still going to proceed based on the pleadings and the sufficiency of the pleadings and follow the normal course of procedure. It seems I am always playing catch up. Well, I'm sorry, mustard. I've been sleeping my life away lately. Well, it's beautiful. It's spring. Spring has sprung. Both you and me have been trolling Chile lately. Well, I'm sorry. Sunglasses. Chile's really boring. He just repeats himself constantly in every video. Okay. Now what has this dumbass filed? Okay. Seeing pantsless Burby twice in one day makes me all giddy. Oh, yes. I like that leg there. You like it? You enjoy that leg? Can I say I live in a van next to Chile down by the Mississippi River? You just did. Incompatible statements like the new trifold is on indestructible paper. You can destroy it. Of course you can destroy it. Direct quote. No, because indestructible paper, like indestructible combs, I don't know if you guys remember those. I've destroyed multiple indestructible combs because I wanted to destroy them because I thought it was humorous to have an indestructible comb and to destroy it. That doesn't mean it's not an indestructible comb. It could be like like that's the title of it, It has to be more than that. Chili needs a boyfriend, but who would take one for the team, Well, he's a good-looking dude. I'm not going to lie. Or at least I think so. What he needs is a psychiatrist. You got this. I heard the indestructible trifold he doesn't sell. He uses them to make forts out of them when he doesn't have a place to crash. Probably keeps the rain off. Another Merb, almost missed it. Back to the beginning and catching up. Well, you go. Nope, he needs a boyfriend to bend him over and give him a good slacking. That would straighten him up for sure. 2 Merb videos? Yes. You got this. Chili needs a boyfriend to cuddle with, and he could also apply Chili's makeup the correct way. Somebody needs to help him out with his makeup. Something to cover up his, you know, I'm being petty. Very infatuated with Chili, very bizarre. Space is fake. Well, he better keep his eyes off Merb's boyfriend, IR else. Or else? Chili spreads false information and herpes. That's not a nice thing to say. When Chili loses these cases, he's going to be on the hook for lawyers' fees, right? Maybe. See, Vlad gets it. And hold on a second. And getting a judgment against Chili is once again useless. It's not worth the paper it's printed on, because a judgment doesn't necessarily mean you get the money. You have to enforce the judgment, and they have to have money to pay the judgment to enforce it, or property. I mean, the guy drives a vehicle he borrowed from someone else. He doesn't own any property. He probably doesn't have much money in his bank accounts, if any. He's essentially judgment proof. So getting an attorney's fees award is most likely not going to help anybody out. No damage claims either. Okay. Aaron, if I was it a long time ago, plus I have standards. Okay. I wonder why Chili doesn't wear eyeliner anymore. I don't know. And this was when I thought Chili was a woman. Clearly I was drunk that night. Lol. Aaron Queen is infatuated with Bao, but it's not bizarre because so many people are also infatuated with Bao and his ideas for a weasel farm grift. Merb, does this case slip blah, blah, blah? I don't know. You tell me. That sucks. I hope you're able to get the sleep you need soon. You get a lawsuit. You get a lawsuit. Everybody gets a lawsuit. All we have to do is look at the recent Dominion versus Fox settlement to know about that. Do we? Hashtag Trump. Chili's been gathering evidence that he really is a news reporter. Okay. D's versus nuts. Got him. Trifold version 2 now with rubber band. Is rubber band indestructible? No comment. Rubber band is the game changer. Use rubber band to practice being torture cuffed or seatbelt cuffed, which is apparently equally as torturous. Torturous? I don't know. The rubber band is free to all new customers. Absolutely, because that's what was missing. What's good? Chili doesn't believe you need a driver's license, insurance, and registration, but his new trifold has a special slot for all three. I tried showing up on time, Merb. Are you wearing pants? No. A gray rubber band, clearly a collector's item. Rubber bands. Why are we all talking about rubber bands? Do so well sitting in the sun every day on a sun visor. Am I right? Do they melt or snap or what? Where's the big cock? Is he in bed? No, they crow really pretty much in the morning and in the afternoon. Like, actually, you probably will start crawling here soon. Lowell for real, Vlad. Merb is always pantsless. That's what makes him Merb. Big companies will settle rather than pay for a trial. I just got here, though, so I don't know the subject. It depends. Sometimes big companies will go all the way to trial to prove a point. They're indestructible like my trifold. Hey, y'all prepare yourself for the rubber band, man. This is just mishmash gobbledygook. Soak the rubber band in Nutella overnight before using. Indestructible rubber bands at no extra charge. The rubber band could easily be construed as a weapon. The absence of evidence is not the evidence of absence. $5 million. So what's everybody think about that Paul and Slave dude? I recently just seen the video he made with Chili. Yeah, he's a fucking retard. Delete funds. The end is near. The end is near. Wonder if Chili knows that having all your info in a jock sock pouch on the visor is not a good way to improve your chances, or is a good way to improve your chances of identity theft. Well, Chili is a goddamn genius, okay? Grasping for straws, going full Sovsit. What value would you place on Chili's identity info? Not much. He probably doesn't have any credit. I've seen that about Chili. I agree with 1000%. Now serving ice cold word salad. Chili racks up fat lines. Chili beans blurs the lines of. I think Chili draws huge lines. That's his problem. Mer Beast. Do you ever sleep? When I can. 0. It's just a great way to make minor things arresty. to receive a deferment, doesn't one have to admit guilt? Not anymore. Back when Chile did it, he did have to, for a pretrial diversion, he had to plead guilty. Nowadays, you have to plead not guilty to get pretrial diversion. They changed the law. But back when he did it, you had to plead guilty. Chitler keeps his rubber bands wrapped around an empty bag thing people punch him in. Nice. When God was handing out brains, Chile took a deferment. Quashed the lawsuit with a squash motion, ASAP. If this gob of motion fails, can he file anti-slap? I think so. California has really good anti-slap statutes. Mixing steroids and meth is bad. I will take your word for it. Does Chile give you a headache as much as he does us? Sometimes. You get a rubber band, and you get a rubber band, and you get a rubber band. Why doesn't he just use Norway versus Jose or No Way versus Jose? Well, that is the winning case. Hello, everyone. Hi, Merb. That's a lawsuit. I think he was mixing more of that brother. Just saying, okay? Hey, Arntonator, how goes your muffler bearings? But Merb, is there really a genuine issue of material fact? Hey, orange cones. They are lubed quite nicely now. Nice. Mixing stupid with anything is bad. Hi, Terry. Good to see you. Meth and herpes medication. Nice. I hear that. Nothing like filing a motion every 3 months just to keep from having a suit dismissed. Chile uses the number of suits filed as flex. Yep. I'm getting my AC compressor rotated. Nice. Doesn't Blue Bacon make good points about having 1983 and Bivens immunity by being a Leo? See, Lyncher's a little shit stain, but if Blue Bacon thinks he has 1983 immunity, that would require him being in federal court, number one. And number two, he would have to be sued in his official capacity as a law enforcement officer. And he would have to be a state actor, i.e. a state law enforcement officer for 1983 for qualified immunity. For Bivens immunity, again, he would have to be acting in his official capacity as a military police officer. So I don't think Bivens or 1983 apply. Chile isn't suing 1983. Chile isn't suing Bivens. And so qualified immunity for those two things wouldn't apply. So I don't know what you're trying to say. I don't know what Blue Bacon was talking about. Qualified immunity would not apply to suing a law enforcement officer outside of their official role as a law enforcement officer. If a law enforcement officer breached a contract and you sue him for breach of contract, he can't claim qualified immunity because it's so fucking complicated. So it has to be a deprivation of rights, and the right has to be clearly established in order to defeat qualified immunity. If it's not clearly established, qualified immunity applies. But it has to be a lawsuit for 1983, that'd be against a state actor, or Bivens, which would be against a federal actor for a violation of rights. And then if that right is not clearly established, then qualified immunity may apply. This is why I don't respond to most of Lyncher's shit. It's because it's off topic and it's generally involves a lot more discussion than I want to have. Laughing, need to borrow a hamster. That's fair to say. Thumbs up or something. How you doing? I'm now selling herpes cream in my merch store. Nice. Laughing. The rubber band has one big hole, just like the one in Chili's head. Why would someone buy a cream to get herpes? Well, how else are you going to do it? Obviously, it doesn't work. Donnie like a headband. Peters and Truth? I don't know. Those don't go all together. I know, but I think she actually had the evidence that she was talking about. I'm selling non-destructible trofolds in my store, okay? Oil and water. Since Merv hates pigs, I'm going to use guinea pigs. I hate pigs. I love pork. Chili and Truth? I don't know. Those don't go together. That's true. That may work. Fuck, I need Tylenol after hearing this shit. I know. Great work, Merb. Chalito is a criminal worthless liar. Okay. Is the AI Chitler thinks going to be part of his team taking the piss out of him already? Hope you stay out for WWN. Gia has been practicing her knots. So this judge is in for a good time. On the California case, yeah, it's going to be a shit show. I don't have any money. Can I get for free to build a fort out of him? It worked for Chili when his van was stolen. The air in the abyss that Chili calls a head leaked into his knee, causing that high knee pressure. He just needs a refill. I hate it when Merv gets ahead of himself. He never uses his turn signals. Sorry. Since Blue Bacon doesn't contract with Chili, how can this lawsuit go forward? Good question. I've been out late. Got to get back in the dungeon before Gia gets home from work. Like blinker fluid. I use them to build a fort down by the river till I get on my feet. Kind of. Chilito's being a dummy again. I'm shocked. Yes, I'll email you 100. You better she doesn't kid around. Everyone, I have to walk my beast. Have a good and safe day. Have a good one. Doe, a deer, a female deer. Ray, a drop of golden sun. Ciao. Thanks. Chili suffers from oxygen deprivation. He has his head too far up his ass. It's jail Warren, no tea. Sorry. Isn't Merb a masshole member? No, I'm not. I am, and I still haven't received my promised personalized lawsuit. No more than you are. As shocked as Chitler's claim of being punched in the nuts, he doesn't have. Same here. Do you feel left out, Steve Miller? I haven't either. Maybe we should form a support group. We can call ourselves the Jockstraps. Bias Peter. I'm a major in the masshole army. I take my rank seriously. Well, okay. I'm an underboss. I'm sorry to hear that. How much GHB did you get busted with, Chili? I don't know. Major masshole, sir. Is anyone using delete Decastro yet? Exactly. There are no rankings in the masshole troll mafia. It's reassuring to know that I'm not the only one who's not feeling the love from the self-declared most powerful force in the universe. Okay? I'm AM7, okay? You are a fake. Delete laws. The real would not come here. Oh, you're smart, Katie. Natelle. That's major asshole. There is no M. Not much. He has zero proof of it. It's just an allegation. Yes, that's what you put in. That's what you put in complaints or allegations. That's a lawsuit. He may not own any property, but he rents a lot of space inside his head. Okay. Look out. She's on to you, bro. Okay. Really based on what? But she stole my van. Get the car gerbs. Chili is a bit of a sissy for an alpha. Yes, he is. Did you spot an imposter? The real deal has everyone blocked, so we wouldn't see him, Katie. So true. Just something to play with. I got something for you to play with. I show my privates in public. Nice. Who owned that van that got stolen from Chili? Anyone ever find out? I find it hard to believe it was his. Why? I mean, it might have been. Based on you hurting my feelings, that's always a lawsuit. Chili would come into the stream and say, and only see two people and say, I'm more popular, I win. Chili's an alpha in the same way alpha and beta versions come out before the official release. How'd you figure out that was a fake delete laws? LMFAO, how old are you? You can easily show Chitler is limited by watching him. How old would you like me to be? Who is fake? Merb is fake. That's an AI Merb. That is true. I'm 48 and a half. Did not Chili call himself a public figure in one of the mass court cases? It doesn't matter. It's going to be a finding of law. It's going to be whether or not the court in California determines based on the facts that Chili is or is not a public figure. That's what it doesn't matter what Chili calls himself. You have to specify mentally or physically. AI Merb with no pants. Absolutely. Clearly. I believe it was in his court case. I really don't care. Your reasoning is ipong. You do care. You're responding back. Can he add videos from unnamed parties as part of his little suite? Little suit? I mean, he has videos by John Doe's, who he hasn't named. I also assume he has to serve them as named parties and not just their videos. So if he's actually going to sue someone for copyright infringement, he's going to actually, number one, have to have a copyright. Number two, he's going to have to name them as a defendant. So if he's going to tack them onto this particular lawsuit, he's going to have to amend it to include them as a defendant. If he is going to sue them separately in a separate lawsuit, he has to name them as a defendant. Has to be named, and they have to be served. Young. Nana Boo Boo, stick your head in doo doo. Oh no, not Yupong. That's really bad. Lol. Super necessary human. That was hilarious. Merbs had a shower, I assume. His cock isn't loud as F. Sorry, bro. You've been epunged. You left your panties in my van. Oof. Sort of the same as based on the fact Chili said he got assaulted by a breast likely means he is a bitch. Yes. Don't get too wrapped up in haters. Oh, headers. My bad. Sorry, I typed too fast. Oh no, the horror. You are everywhere trying to get attention. He is, and you give it to him, so great. DL might be in here. He wrote on his CP that he is in someone's live chat somewhere on YouTube. Okay. Do I have your attention now? Bow our heads and pray. Why is he praying for relief? Jesus isn't going to help Chilito El Pendejito. That's what they call it, the prayer. That's what you're asking the court for these things. It's probably just an old term that's just stuck around forever. I like you. I have a sense of humor, though. You're committed to it, if nothing else. Okay? I'm the mole. If he said it, it was likely a lie. Heck no. I read your comments all over the place. I usually ignore you, but later I'll say hello. Pendejito is a diminutive of pendejo. I identify as a unicorn. Look, Katie made friends. Good for Katie. C, because he is chiquito. Chili or pretender, and because it rhymed. Hey, Ironton Otter, got a pic, a t-shirt. Never thought I'd be a grumpy old man, and here I am killing it. Delete laws, your mods booted me out when I pointed out you lied about that cop saying shit he never said. Has Chili's case against Kate been ended? No. He has a couple against Kate now. Careful. Are you in need of my trifold version 2.0 now with a rubber band? Trifold, ass paper. Possibly. Does that mean we're friends? The trifold now comes with a rubber. Will the real delete laws please stand up? Hey, Merb, don't forget the card holder. The rubber band was the game changer. Yeah, we get it, dude, with the rubber bands. You guys are a little bit simple. Okay. Still not worth $30. Not to you. Yes, that is a must-have. How can I help you with a lawsuit? Hearts, not worth 30 cents. Hi, Merb. But it's a black rubber band. I thought it was gray. I thought you said it was, somebody said it was gray. Unless it's a delete laws branded rubber. I rubber banded an indestructible trifold onto my front bumper, so now my car won't get damaged in a traffic accident. That's good thinking, actually. Buy my $7 version, now with less rubber band. But Steve, it comes with a velour document pocket. Nice. I'm still subbed to this turtle boy lover. Ew, lol. Fucking weirdos. June making me laugh. Hello, how you doing? F-16, the military's coming for you. Low-fine Cox, Merb, haha. The logo band is in Trifold 3.0 and will cost $60. Are you under attack? Sounded like a fighter. It was a bigger plane. I don't know. It wasn't a fighter plane. Air Force is coming to get you. Hi. Can I give you $1 to have you on standby? Delete. F-15, how rude. Delete laws, branded rubber, aka a jock sock. Didn't know you lived on an airport. I didn't either. I thought I lived very far away from an airport, but apparently that guy, he was flying low and fast. I don't know. Hi, Inigo. We have air bases all over California. Oh, delete laws. Send me one with the rubber band. Make it snappy. Get it. Make it snappy. Rubber band snappy. You're welcome. Merb is under attack. Wasn't the trifold $25 before, but the rubber band increased the price. The phrase subject of this cause of action is confusing. It seems like it could refer either to a person or the reason for the suit. Okay. Yeah. Chile called in an airstrike. Merb's being swatted. Not today. Jet was flying low, trying to get a peek at No Pants Merb. I'm under a gazebo-y thingy. I don't know what you call it. Hello. There's a recession going on. I need the extra $5. Don't we all? Hey. Peter's accusing someone else of making false, irrelevant, and improper statements. That's Rich. No, that was Puritini. You've got Kate Peter on the mind, and I understand she's got big tits, and they're very tantalizing, but you need to let it go, bro. Puritini does not have big tits. Where are your trifolds made? True that. Trifold factory, of course. Handmade by a constitutional law scholar. This isn't Kate's writing, it's Blue's. I know, but they're so identical. They're so similar. The Delete Law's manufacturing facility is top secret, but located in Thailand. Eddie? Right. Well, next thing you know, she will accuse someone of theft. That's a lawsuit. At Constitutional Scholar headquarters at the Indestructible Factory. Get a real job with benefits and retirement. Stop leeching off the government the rest of your miserable, lazy, worthless criminal life. Relax, Peanut. Relax. That's not the real Delete Laws. Relax. It's okay, buddy. Lots of young men there. Damn it. If I had warrants out on me from several states, I would spend all of my time hassling on-duty cops. Maybe that's why Floyd Wallace was really in Thailand hammering out a trifold deal. Stop it. Chile is allergic to facts. Sorry, I never stop. We don't stop. A spell and grammar check would seem to go a long way in preparing a lawsuit. Yeah, I mean, but you get done, and I mean, I understand it. I've let more than one typo slip past me. Does a Commodore 64 come with spell check? I don't know. I missed this C64. How about an Etch-a-Sketch? I used to have an Amiga. 0 spell check. I forget. Why does Merb hate Blue so much? I don't hate him. I would have to. That requires far too much energy. I don't like him because he is a know-it-all who doesn't know it all. And I've never been a fan on anybody on either side of the auditor, anti-auditor aisle who pretends to know the law. That's part of my problem with Chile, is because Chile pretends he knows the law and he misstates the law and misrepresents the law. Blue Bacon does the same thing. So I have the same issue with him I have with Chile. And hate is too strong of a word. Do I hate Chile? No. Do I hate Blue Bacon? No. I just don't like what they do. And, I'll be perfectly honest with you. I've stopped watching Blue Bacon. I haven't watched any of his work in a long time. So, I mean, he could have changed. So who knows? But also the issue with him lying, I'm just not a real fan of liars either. And unlike Kate, Blue Bacon doesn't have big titties. So 0 redeeming value. Chile for governor of Fantasyland. Same. I had a C-128 also. Floyd smuggled the rubber bands in for Chile, and now Floyd thinks he's banded. Okay. Get a job and stop lying on YouTube. No. Blue Bacon sends his Discord over to Merbs to call him out when they disagree. Okay. Delete laws doesn't mean you don't make them. Playing in the band. He's a legend in his own mind. Facts. We don't need no stinking facts. Tuba. YouTuber. Kate is a liar and trash and has bought a lot of subs. Well, I don't know if she's bought a lot of subs. Why doesn't Blue Bacon settle out of court with Chile for the used couch he wants? Well, that'd probably be a good deal. Blue Bacon is a pussy. No lie detected. God, you are worthless, wanting something for nothing. Only lawsuits and excuses. I'm thinking unrequited love. Never talk about fight camp. Ha. Okay. It's not his fault he looks dumb in his filings. He's too cheap to download the real AI lawyer program and uses the retarded AI called Google. Okay. Thanks for the stream, but I don't know why, but I could listen to you talk all day. Well, thank you. Pulling a gun on a janitor at the Airbnb had nothing to do with his eviction, right? Probably not. An air tag. Blue bitch is going on and on. He got caught and could not responded, he called and asked to get added. Blue bitch is going on and on. He got caught and could have not responded. He called, asked to get added. Okay. No, because reasons. Basically, Chili is suing because reasons, and Blue Bacon says no because reasons. I think he likes being in court. Get a lawyer. Yes. Hasn't failed to appear yet. Yet. Chili is suing, so it looks like he is a game changer and he doesn't need to win. I'm deaf, but I like listening to Merv. Well, deaf people probably appreciate the dulcet tones of my voice more than people with hearing. U.S. Air Force Boeing KC-135R Stratotanker. Okay. How can he be a man of laws but wants to delete said laws? Best way, Donnie. Chili is a big old nuisance. Stupidity. Citizens arrest. Not enough. Chili just hopes someone will settle a case and he gets a free bag of Funyuns. Nope, 911. I'm not stupid. Is BB trying to say Clement was trying to arrest Chili? I think he is. I think that's what he was trying to say. And that's pretty fucking stupid. Merv, is evidence found as a result of an unlawful citizen's arrest subject to Wong Sun? You tell me. Why do you do this to yourself? Because I'm dumb. Press X to doubt. Okay. 69. The guy was an idiot, but he wasn't trying to citizen's arrest. Everybody knows that. So wait, is Blue Bacon defending that fat retard now? Yes, apparently he is. Wow. Then why was Chili asking to be frisked and requesting a full cavity search? Well, because he was hoping that Clement wouldn't punch him in the balls and would learn how to fist right. I'm not so sure Clement wasn't just a Chili fan helping him look tough. I don't know. I'm still convinced Dan was a paid actor. Well, I don't know. I'm going to hire a pro bono attorney. Chili is too short to do a real 69, so it's just him sucking off a truck stop hobo. Okay. If he was in so deep as he was against Chili for weeks before the incident, and he's just now being sued. But did he really get sued? The case isn't moving at all. Well, in the sane way all people are being sued by Chili, it's been filed. Those flowers behind you are beautiful. Have a great evening. You too. Clearly, 407 second. I don't know. Damn, I'm late. Sorry. Ad infinitum. Chili, just ask him. True, but it doesn't mean anything unless it moves forward. Shalom. Greetings, Chili chat and guest. How the fuck I end up here? That's what I ask myself all the time. Just give Chili time. He can accomplish that. Third warrant, Chili's winning. Merb, do you see any beehives in the future of your farm? Possibly, yeah, I've thought about it. Anyone know how Chili's boy is? It took Chili 3 months to file 1.5-page supplemental. Sure. Go after his Nevada-based company then. His company doesn't have any money in it. Garnish his money transfer apps. He could just change bank accounts. The National Guard is coming for you, probably. What up? Y'all need to admit it. The trifold ID is actually a good idea. No, it's not. Tastes great or less filling? Tastes great. How is your blood pressure? When I read things like this, it's probably pretty high. Has a trifold saved anyone yet? No. How do you think the parties involved in this case are doing at Blue Booking? Probably not well. McAddick saved anyone from what? Okay. Birds aren't real. Sure. Does Merb? No, he doesn't have to read every comment. If not, this is funny. I know. This is... People don't understand sometimes how stupid they are. And they put comments in my comment section thinking that they're smart or they're making a great point. And they're really fucking stupid. And this highlights how stupid they are. I mean, I just put a heart on every comment in my comment section normally. Just show I've read it. But here you get some actual feedback. You get to see my face when I'm reading the dumb shit that people write and the shit tier takes that they make. You get it. You get it here. This is my pro bono service to you, the commenter, so that you can see if you're really witty or you're really fucking stupid. And I hope, because I don't really care about subcount, I hope that this will actually thin out some of the stupid people who think they know too much, who think they know things that they don't know. Mechanics, no one has ever claimed the trifold will save anyone from anything. It's just relevant knowledge for traffic stops. No, it's not. It's not. It's terrible. It's stupid. I've broken it down. It's useless. It's trash. You can't even wipe your ass with it. I mean, it's that useless. What about Bell and DeVoe for the Bell Bivens DeVoe immunity? Nice. Relevant or just wrong and nonsense? Sure. Blue Bacon is a tuba player. No immunity. Merb isn't Blue Bacon acting in his official capacity. That's why the entire DOD went after Chile. I don't believe the entire DOD went after Chile. Yes, relevant. You must not know what that word means. Okay. Is it safe to assume Mr. Wish has been dismissed or not yet filed his withdrawal? In order for him to bow out, he has to file a motion to withdraw. The court has to grant it. Now, if Kate gets another attorney, then it's just a simple matter of this attorney out, that attorney in. But to go from having an attorney to a pro se status, the court needs to authorize it. And I've not seen Wish file the motion, so Kate is still being represented by Wish. So he has not been dismissed, and he will not be dismissed until he has filed his motion to withdraw and the court has granted his motion to withdraw. Or you haven't read the trifold. Maybe he's made some mistakes on it, but again, I say the idea of a trifold is a good idea. No reasonable person can deny it. I can deny it. I think I am a reasonable person. I'll tell you why. It's because you don't argue law on the side of the road. You don't do it. The law is fairly fact intensive, and the law is more complicated than a cop has knowledge of. And it's certainly more complicated than what you can condense down to a trifold. So you're giving someone a false sense of authority. You're giving someone the idea that they can argue with the cop, and it's not going to be beneficial either for themselves or the cop. Every attorney out there is going to give you the same advice. Shut the fuck up. You get arrested, you get detained, you get pulled over, you shut the fuck up. You don't engage with the cops. You don't argue case law. You don't state or restate facts. You shut the fuck up. And the reason why attorneys tell you that is because it makes our job easier to defend you if you shut the fuck up. So I don't know how much clearer I can make it, but shut the fuck up. Don't pull out a trifold. Don't start arguing case law. Shut the fuck up. Make it easy for your attorney to get you off the charges. Don't talk yourself into charges. We get it. That's Fabio, by the way, in case you're trying to differentiate between their calls. What kind of an attorney are you? I'm a California attorney. I do all sorts of cases. I've done criminal, civil, probate, family. Most of my work is civil and family. But I guess I'm just a first-year family law attorney. The trifold is Chile's misinterpretation of case law. That too. I can deny that Chile has any clue what would be helpful for a normal person during a traffic stop. Shut the fuck up. Simple advice. Put that on a trifold. Shut the fuck up. On a trifold. Done. Example, Rooster. Chile has announced he's on a live stream somewhere on YouTube. I don't care. No one with a 5th grade education would think a trifold is worth more than something to scrape bugs off the windshield. Okay. Chile is the constitutional clown. Okay. You don't think it's good to know that we have the right to stay silent is a good thing. Dark watch. Do you need a trifold for shut the fuck up? If you need to pull out a piece of paper to remind yourself to shut the fuck up, then get a piece of paper for free, just any piece of paper, write shut the fuck up on it, fold it up into thirds, get a rubber band. You could usually find them laying around. Maybe you've got a junk drawer full of them. Rubber band that folded up piece of paper that says shut the fuck up on it to your visor. Boom. You have a better trifold with better quality information on it than anything Chile has ever churned out. You're welcome. And I didn't even charge you for it. Why would anyone join his site? Tell him all of your information, and when he gets pissed at you because you disagreed with him and he sues you, you just told him where to serve you. Who cares? Don't hide from service. Let him serve you. Cressy will just put the future inmate daughter on the stand. Cressy will just put the future inmate daughter on the stand. What the fuck are you talking about, dude? Merb, are those hibiscus flowers behind you? That's a cool backyard. Oh, Ron. Okay, Ron. Is Balake here? When have you ever seen Chili remain silent? The dude is incapable, physically incapable of remaining silent. And he's talked himself into arrests. Aaron, the trifold is filled with incorrect case law that has been proven over and over. Yes, fair use is not a crime. Okay. But he spent a lot of money on trifolds. They must work, authored by a try-hard narcissist with no bar license. You think Chili is good looking? From this woman's point of view, ew, no, he isn't. Well, I'm not a woman. Well, Aaron, Queen, any person with A5 IQ or above learns that in elementary school. Jarvisda, example. I love when Kate is not involved in this. Stop fantasizing about her. Stop inserting her in places she doesn't belong. Dummy. Potentially Criminal did a video on it, and so did Merb. Dark Watch, per usual, you have nothing intelligent to say. Y'all must not have heard him say that he is a constitutional law scholar. He will sue everyone that is laughing at him, probably. The trifold is a shit product, not even an original idea. Pergalo. You have anything to say about TB trying to make contact with the defendant right after he got a harassment order granted, or is this still the Chili and Kate show? I have nothing to say about that. I don't know about it, and I don't care. Pergola. What? McAddicts. Oh, and just for the record, Sam, Turtle Boy's a piece of shit. Kate's a piece of shit. They're both pieces of shit. Equally pieces of shit. Chili's a piece of shit. They're fungible. Any one of them at any particular time, you place them in any situation that the other one's in, and they all do the same thing because they all are shitty people with shitty responses to the same fucking shit. And I don't know why you guys want to talk about Pergola. What? McAddicts, who has ever made the claim that the trifold was made to, quote, save anyone? Actually, is the G-Series account still open for donations? That's not the only thing that's open for a donation. The more we chat, the longer Merv will have to say. Trifold, actually, I could leave it any time. Trifold dare made at the Willy Wonka chocolate factory. Chili's claimed it, Aaron. I feel bad for the judges who have to read this nonsense. Yes. McAddicts, never heard him say it. Only you clowns creating straw men fallacies. Lowell at Delete Laws. Chili's made videos on how to use the trifold, and I think stated it would save you from tickets. Merv is actually spot on about blue bacon. Trifolds are made at the Willy Wonka chocolate factory. Then turn the volume up, Aaron. He said it in multiple videos. Chili, suppose MMA fighter, Lowell, dream on. I think he said he just went ookie on him. I think he just sparred with him. They trained against him. Every time I see a copper, my butthole tingles. I touched Kate's boobie and I liked it. Kate's nips point at her toes. Probably, but they're still big. Big boobs. Everybody likes big boobs. Chili needs a job at McDonald's. Merb, are you on the new set of Brokeback Mountain? Hell yeah, brother. Hell yeah. I can't quit you. To the break of dawn. Merb, are the people allowed to fundraiser for the states to get Chili extradited? I don't know. I don't think that'd be a good proposition. Little Chili's beat up 4 cops, 3 Girl Scouts, and 2 Velociraptors at the same time. That's tough. That is tough. Chili's not qualified to work at McDonald's. Say goodnight, Merb. Chili, suppose fight Josh Abrams. Ever find Matt Decastro? Don't explain. I'm very dumb. I admit it. I am a mixture of both. I'm new to Abrams' channel. Who is correct in this? Did Josh know HTTG was scamming people or not? Did he abuse her or not? But I like writing stupid shit. I know you do. Is that AA, Ron? Merb thinks knowledge is useless. No. Too little knowledge can be more harmful than not enough knowledge. I never said knowledge is useless. The appropriate amount of knowledge for you at a stop is to shut the fuck up. That's the appropriate amount of knowledge. That's all you need to know. That's knowledge, and it's useful. Beyond that, it's useless, and it could cause more harm than good. Ron, name one time the trifold ever helped anyone, Aaron. Merb, are there some circumstances during an investigatory detention where you would recommend talking to the police? No. Don't say F. Such as if you are a repo agent and someone accuses you of grand theft auto. No. Let them figure it out. Or sure, maybe say I'm a repo agent and stop it there. But I wouldn't even say that. I mean, you don't need to say anything. If you're a repo agent, then you probably have a contract or something. Hand them the contract. Hand them the authority for it. And shut your mouth. Shut your mouth. Because what if you repoed the wrong car? Shut your fucking mouth. Just shut your fucking mouth. Well put, Merb. Chili has a big mouth. Merb is a smart attorney. I wouldn't say that. Merb has been a first-year family attorney for many, many years. Not enough, apparently. I can share many examples of people using the knowledge that is shared on the trifold, such as keeping silent. That's helped. So this one thing on the trifold is useful. Great. Now, surrounded by a bunch of shit, and it becomes more useful or less useful? I would say less useful, because you've surrounded it with shit. You have one true thing that everybody knows, and like, oh, well, this is true. And then you surround it by a bunch of false things. People are like, well, this one is true, and I don't know any better, so these other things must also be true. But they're not. And it gets people into trouble. You're a fucking idiot, Aaron. You, sir, are an idiot. And you're not making convincing arguments. You keep making arguments, they're just not good. Because you're stupid. And you don't understand. And you have an agenda. See, if this was actually a useful trifold, I'd shut my mouth. I'd be like, okay, it's a useful trifold. Good on you. Because I don't want to see people go to jail. I don't want to see people get arrested. But it's not. So take your hint. Name one, Aaron. Some people is not evidence. I know it's completely anecdotal, and he can't even do it. The right is useless if you don't have the ability. Most people aren't smooth enough to talk themselves out of trouble. No, you shouldn't talk yourself out of trouble. You should shut your fucking mouth. Sophie, I can't share links here. Well, you're still stupid. Do you need to be reminded to stay silent? Apparently, Aaron does. I agree. That doesn't take away from the knowledge shared in the trifold that says to remain silent. Again, one valid point out of how many cases? You should shut the fuck up, Aaron. If Chili sued me and I didn't respond, what would really happen? He would get a default against you, and then he would struggle to figure out how to get a default judgment. And in the default judgment, he'd have to go through a prove-up hearing. In the prove-up hearing, he would have to basically convince the judge that, assuming all the facts in his complaint are true, that he would win as a matter of law, and that he would be entitled to the damages that he claimed. And I wouldn't leave it to that, but I wouldn't trust that the judge isn't going to award him a bunch of money. I say it's unlikely that the judge is going to award him a bunch of money, but you really should fight anytime he sues you. Hire an attorney and fight. Sometimes when you make a police report, LE, for whatever reason, feel the need to investigate you. How do you know when to plead the fifth? You're not clear when something turns into an investigation. Don't talk to the police. What about Brett Matthew Caloran? I don't know. Why didn't Chili take his trifold's advice to remain silent? Because he's incapable of it. Let's see him, Aaron. Do they still teach civics in school anymore? I don't think so. Maybe. What's happening with Earl Warden? I believe his appeal is ongoing. I love how well the trifold worked when Chili got arrested. I know. TB literally bragged about using harassment or silence tonic and threatened to follow him around and get him arrested. No, that is being a shitbag on a major level. Come on. They're like, what do you want, dude? What do you want? I've already said Turtle Boy is a piece of shit. What do you want? I don't care about the specifics. You're a fucking idiot. You, Sam Stone, are a fucking idiot. Go fucking shill for Kate or whoever the fuck you're shilling for somewhere else. You're a piece of shit. Move on. Some of these people, man, geez, I know. Then telling me that was kind of useless, Aaron. Trifold got toilet paper. Lol. I don't know what that means. I'm an idiot too. Yes, you are, Lyncher. Well, manure is a fertilizer. Lol, no. What Merb said, bam. Trifold makes good toilet paper. No, it doesn't, because it's laminated with the indestructible paper. Same train of thought as Maria. Are you surprised? Hey, he may be telling the truth. Perhaps the officer didn't want to deal with the person Aaron is talking about. Maybe the officer was new and didn't know what to do. Or maybe the officer just didn't fucking care. Officers have discretion on whether they make an arrest or not. Still doesn't make Aaron's argument right, just saying it may be possible. In Texas, they teach civics. Good. Wait, are you really? Shut the fuck up, dude. An indestructible trifold makes excellent toilet paper. It's what's most suited for. Well, I don't know. I don't think so because I disagree. Thanks for watching. Have a great day.